10 seconds, 5 seconds. Start. The learned counsel submitted that the judgments relied upon by the respondent in Amritsar Gas Agency, Rajasthan, Breweries Limited, Royal Orchard, etc., are not applicable to the facts and circumstances of the case. Alternatively, learned counsel, without prejudice, by not admitting that the lock-in period had expired, stated that to evoke Article 35 2A even after the expiry of the lock-in period of 5 years on the ground of shortfall of financial performance for 3 consecutive years, the same must be for the 3 consecutive years relating to the period after the expiry of the lock-in period and not prior to it. That apart, he stated that even the physical possession of the hotel is with the petitioner. In this regard, he has referred to Article 2, for which gives operator a right to lease, sublease, or grant concession, etc. Article 5, 9 and 10 provides that operator would operate without any hindrance and owner will not interfere in the day-to-day operations. He also referred to Article 6F, which provides that even for inspections, owner has to give a prior 3 days written notice. He also refers to Article 19 2B to contain that the owner gave an undertaking that the property was not mortgaged or charged to adversely affect the rights of the operator. He also states that Article 23 clearly provides that the operator has to be compensated before vacation of the premises by the operator, and Article 25 subclause 2A 3 and 5 provides the right to recover projected 3 years fees or interest before vacation of the premises. He stated the agreement creates an interest in favor of the petitioner in the hotel and the petitioner has an indefeasible lien and charge over the hotel and to preserve and protect his possession thereof as contemplated by Section 202, read with Section 221 of the Indian Contract Act 1872. The respondent can only seek possession of the hotel from the petitioner consistent with the settled jurisprudence which mandates by virtue of various of decisions of Supreme Court by taking resource to due process of law and not illegally or forcibly. In this regard, he has replied upon the judgments in the cases of Kavita, Tehran and others versus Balsara Hygiene Products Limited and Southern Roadways Limited. Madurai respondent by its security versus S.M. Krishnan SC3. A reply to the petitioner has been filed by the respondent, Mr. Gaurav Sharma, learned senior counsel appearing for the respondent, would submit that the petitioner carries on the business of operating hotels in India and the respondent is a hotelier in the city of Dehradun, Uttarakhand, who owns the hotel. On May 15, 2015, the petitioner and respondent enter into an agreement for the operation of the respondent's hotel at Nanda Ki Chowki, Chakrata Road, Dehradun, Uttarakhand, called Regenta LP Villas. The agreement is a commercial agreement in the nature of an agency, which allowed the petitioner to operate and manage the hotel of the respondent as an agent of the respondent in consideration of management fee. The commercial operation of the hotel started in July 2017.